With 7 of the 9 Supreme Court justices eligible to retire, it is critical that the process to replace them is wholly transparent. Recently, we were mortified to hear the words of our Chief Justice, Beverly McLachlin, reported in the Times of India, where she reportedly said the process of selection and the reason for recommending or not a name for judgeship can never be disclosed. Judges' selection is entirely confidential. We do not street. Our forefathers valiantly fought to wrestle legislative power away from individuals to place it in the hands of democratically elected representatives. Today, this has partially been reversed by the philosophy of our Supreme Court. Our Chief Justice declares that there is little point, and I quote, "There is little point decrying the fact that judges make law. They do and they must." She goes on to explain that the lawmaking rule of the judge has dramatically expanded. Judicial lawmaking is no longer and always confined to small incremental changes. Increasingly, it is invading the domain of social policy. Once perceived as the exclusive, we are asking Prime Minister Stephen Harper to begin an open process that will result in the appointment of strict constructionist judges who will, in the words of the U.S. Supreme Court Justice Sonia Sotomayor, our judges will have fidelity to the law. Judges do not write the law, they interpret the law. This is the most important issue of our day. Out of control lawmaking judges have changed much of the legal fabric of our nation. 15 years ago, they legalized 2 types of child pornography. Other actions of theirs have reduced the age of sexual consent of sodomy down to 14. They have also redefined marriage and made many other dramatic social policy changes to the law.
Sort of 10 years ago, at the end of the Lemaire Court, there were a lot of complaints about activist judges. I haven't heard that too much. It's now the 10-year anniversary of McLachlin's court. How do you sort of, when you look back at those 10 years, how do you rate her court on those sort of old complaints of being activist?
Well, I think this is the most activist court that Canada has ever had, because it has it has changed many of our laws, and further to that, that our Chief Justice, Beverly McLachlin, goes around this country teaching judges to be lawmakers, social policy lawmakers. That's the very definition of an activist court. So not only do we have an activist court in the Supreme Court, but of course the Chief Justice is the spokesperson for the judiciary right across the country. And she even teaches judges that before you is a bipolar dispute, but within that dispute you can find a polycentric charter issue in order to write laws. That's part of her lecture. That's part of what is presented on this tape. And again, I think that flies in the face of what average Canadians believe. We don't think that appointed, hired individuals should be writing laws upon which we must live by. We think the democratically elected representatives should do so.
McVety, some people will make the exact opposite argument, that the court indeed went out of its way to send back the political ball to the parliamentarians. I just think of the security certificates, for instance, that the Supreme Court struck down the whole regime, but then they went on saying, here are examples of what you could do about it, but they didn't say what to do about it. Same thing can be said about bridge schools in Quebec.
Even abortion.
That some people say no, that Ms. McLachlin was sensible to those accusations of political activism, and that she went out of her way to not tell the politicians.
In our statement today, we are saying that this is only a partial reversal on the issue of lawmaking. It's not absolute. It's not across the board. And our Supreme Court, even on the issue of abortion, put the law back to Parliament and said, here, you write the law. I believe that is appropriate for justices to allow the legislators to write the law. But where I believe they step over the line is when they say that we are going to make new law. We are going to be lawmakers. And that is clearly the judicial philosophy of our Supreme Court justice. And boldly, they are saying that the appointment of these judges is confidential. It's behind closed doors. It's in secret. This is not how democracy is meant to operate.
What do you suggest?
Well, we are not experts on appointments. We believe there should be an open system. It should be a transparent system. We believe that the public should be involved in one way or the other. I think if you look at the United States with the confirmation hearings that they have, sometimes those confirmation hearings go too far and allow people to say unruly things about an appointee or a nominee to the bench. I don't think we should go that far, but I do believe Canadians want a transparent, open process that will stand the test of representation. Nobody wants to think that these decisions are confidential behind closed doors and it's an old boys club where this person recommends that person and then they get in regardless of their judicial philosophy.
Now, would you point a bad appointment to the Supreme Court in the past?
No, I think today the process is very much behind closed doors. The public is very much unaware. Even the two appointees by our Prime Minister, Stephen Harper, we are very much unaware of what their judicial philosophy is, and we are in a wait-and-see mode. I don't think that's the best way. You do not wait and see after the appointment. Wait and see what they're going to do. We should have an open, clear discussion on judicial philosophy, what this country wants, how we want to go forward. Or if we just let it go the way it's going, then we are going to get more of the same, and we are not content with that. Yes?
Had a hearing for Justice Rothstein, so we did hear a little bit about his viewpoints.
Yes.
Those hearings were canceled for Justice Cromwell. Would you like to see him bring that back, or does that not go far enough because the MPs didn't actually get a say, they just got to question?
Yeah, well, I think there certainly should be a greater process that opens this up more. In fact, historically, the process has been very regional, where MPs in a local area, knowing that a man or a woman is going to be nominated, they would get involved in that process. It is only of this generation that we have turned to very closed door meetings and then maybe just a sprinkling of openness. We'd like to see a fully transparent process.
States, very political process. You're saying 7 of the 9 could retire.
Yes.
But in the U.S., where it's become overly politicized, you've got Justice Stevens deciding he was going to hang on until there was a suitable liberal in office to name his replacement. He was quite open about that. He didn't want to retire under Bush because he wanted to ensure somebody of his mind was appointed. Does that worry you that sort of thing could happen here?
It does. I think that we as Canadians are very good at striking a balance. I don't think we go down the extremist paths that we see south of the border. I think we can strike that balance, have a good open process, but not just allow people to impugn someone's reputation without merit. That is when it goes too far.
If Stephen Harper's your friend, have you communicated with him about this?
No, we have not, and I have not communicated with him since he became Prime Minister. So that myth I would like to dispel.